Kara, do we have a ruling in the Donald Trump civil fraud trial case?
Yeah, we do, Boris. We just got the ruling. It is 92 pages long, and I'm scanning through it right now. But when I'm looking at these numbers, the totals that the judge is ordering collectively in the case, so this will include all of the defendants, I'm getting a total of $362 million. And I'm just scrolling through this now. I can see that there's the dollar amount specific to Donald Trump. I'm going to use a calculator to do some rough math. It gets us to, for Donald Trump, about $354 million. That's for him, the company, the Trump Organization. So very close to what the New York Attorney General's office was seeking of $370 million. There's a lot of zeros here and a lot of other numbers, but roughly $354 million is the judgment against Donald Trump. The judge also found that his son, Eric Trump, is
now clear about what's happening here. There's significant financial pressure mounting, and I need to explain exactly what's at stake with Trump's properties and business empire. This is a serious situation, and he's well aware of the gravity. To clarify up front, there isn't a new court order issued today specifically authorizing the seizure of Trump Tower. However, the legal and financial atmosphere is extremely tense. Judge Arthur Engoron has found Trump liable for years of persistent business fraud, including deceptive practices with banks and insurers and systematic financial misrepresentation. The penalty is substantial, $355 million plus interest, bringing the total to somewhere between $454 and $464 million. That's close to $500 million he currently owes. If he cannot pay this judgment, New York Attorney General Letitia James has made her position unambiguous. She stated publicly that if he fails to produce the funds necessary to satisfy the judgment, the state is prepared to move forward with asset seizure. The stakes couldn't be higher.
Bring in Paula Reed, our chief legal correspondent, to talk about what she is seeing here, with our understanding here, Paula, that this is really kind of hot off the presses, this ruling.
Yes, the paper is still warm, but we're going through it right now. And as you and Kara were talking about, this case is so personal because it represents such a threat to Trump's business, his family business, and his identity. Remember, it was his identity as a businessman that brought him fame before he arrived at the White House. But in looking at the summary of this ruling, we see in addition to the monetary penalties that Kara just laid out, they have found him liable for fraud, and they are going to continue the appointment of an independent monitor. So back in 2022, the judge installed a monitor to keep an eye on exactly what the Trump Organization was doing when it came to its business dealings. Now, among the things this monitor uncovered were a $48 million loan, for example, to the company itself.
When it comes to legal terminology, phrases like judgment enforcement mechanisms simply mean the state has the authority to seize his assets if necessary. Judge Engoron specifically identified properties on that list, including the 40-story skyscraper at 40 Wall Street, the iconic Trump Tower, essentially his headquarters, and Seven Springs, his estate in Westchester County. Golf clubs, commercial properties, all of it is potentially subject to seizure. Attorney General James is already moving forward. Her office has officially filed the judgment in New York City, the first step toward placing liens on the Manhattan properties. She's done the same in Westchester County, setting the stage for action on Seven Springs and other assets in that area. The legal machinery is in motion, and enforcement tools are ready. The only thing preventing immediate seizure is the appeals process and Trump's ability to secure a bond. Here's where things get particularly difficult for Trump. His lawyers recently informed an appeals court that they couldn't secure a bond for the staggering amount of $454 million. They made extensive efforts, reaching out to more than 30 surety companies. Not a single one was willing to underwrite a bond of that magnitude. His legal team even warned he might be forced into fire sales, selling properties at significant losses just to raise cash. It's remarkable, his own attorneys essentially admitting he may have to liquidate assets at bargain prices. They pleaded with the appeals court for relief, arguing that without intervention, he would face irreparable harm. Surprisingly, the appeals court granted a temporary reprieve. They paused collection and reduced the required bond from $454 million down to $175 million. This gave Trump breathing room, but it's only temporary. If he fails to maintain that bond or loses the appeal, the Attorney General can immediately proceed with asset seizure. The judgment itself is already final. The enforcement mechanisms are already in place. One adverse ruling, a failed appeal, or even a missed payment, and officials could be at Trump Tower's door. It's extraordinary. A man who built his entire image around being a billionaire real estate mogul now faces the real possibility of having his prized properties seized by New York State. The same person who plastered his name in gold letters on buildings may soon watch those very buildings appear on an asset seizure list. The author of The Art of the Deal couldn't secure backing from 30 surety companies for his bond. That doesn't align with the strong, successful persona Trump has cultivated for decades. Instead, it suggests desperation and scrambling as his empire faces genuine threat. Now, let's examine how we arrived at this point. It revolves around the fraud finding in a civil case adjudicated by Judge Arthur Engoron. The case centered on asset inflation. Trump submitted financial statements to banks and insurance companies that wildly overstated his net worth. Properties were valued far beyond their actual worth, square footage was inflated, and asset categories were manipulated, all to secure better loan terms, lower interest rates, and more favorable insurance deals. Misleading a bank into believing you're worth $4 billion when you're actually worth $2 billion is fraud, plain and simple. Judge Engoron didn't mince words. In his ruling, he characterized Trump's actions as persistent fraud, demonstrating a clear pattern of long-standing deceit. He imposed a severe penalty, $355 million in disgorgement, essentially forcing Trump to return ill-gotten gains from the fraud, plus pre-judgment interest, bringing the total to somewhere between $454 and $464 million. That's nearly $500 million owed to New York State. Here's how a judgment like this works. The prevailing party, in this case, the New York Attorney General, now has access to various enforcement tools. They can place liens on properties. A lien is essentially a legal claim against an asset. You cannot sell property with a lien without first settling with the lien holder. They can also freeze bank accounts, adding another layer to this unfolding situation. Attorney General Letitia James has been unambiguous about her intentions regarding the former president's assets. She's prepared to seize them if he cannot pay, and she's taking concrete steps to make that happen. First, she officially recorded the judgment in New York City, positioning herself to place liens on properties like Trump Tower and 40 Wall Street. She didn't stop there. The judgment was also filed in Westchester County, covering Seven Springs, his sprawling 213-acre estate in Bedford, along with possibly other properties in the area. James has identified specific assets on her radar, the impressive 40-story skyscraper at 40 Wall Street that Trump once called the most beautiful building in Lower Manhattan, his signature property Trump Tower with that prominent gold lettering, Seven Springs with its mansion and multiple buildings, and all the golf clubs and various branded properties he's invested in. Every single one could potentially be seized and is on the enforcement list. When someone appeals a judgment, it's standard practice to post a bond, essentially collateral ensuring the money will be available if they lose. Without this bond, the winning party can begin collection immediately, and the appeal doesn't halt enforcement. Trump needed a bond for $454 million, but couldn't secure one. His legal team approached more than 30 surety companies that typically underwrite bonds in exchange for collateral and fees. All of them declined. The reason? Most of his assets are tied up in real estate, and these companies are reluctant to accept that as collateral since it's difficult to quickly liquidate and its value can fluctuate significantly. Trump's lawyers painted a dire picture, stating he risked having assets seized before the appeal could even be heard. They warned about potential fire sales where he might have to sell properties hastily at losses. It's almost ironic that his own attorneys are admitting he could face difficulty liquidating his assets. This is the same man who's branded himself as a real estate titan, now potentially forced to sell buildings at discounted prices because he cannot secure bond backing. There was some relief, though. The appeals court granted him a lifeline. They paused the collection process and lowered the bond requirement from $454 million to $175 million. While still substantial, $175 million is more manageable. Trump secured that bond, buying time and stopping immediate enforcement, allowing his appeal to proceed. But let's be clear, this is temporary relief, not victory. The underlying judgment still stands, and he still owes $454 million or more. If he loses the appeal, that entire judgment becomes due immediately. If he cannot maintain the bond, collection can resume. The assets remain on the list, liens are in place, and the enforcement machinery is ready. It only takes one adverse ruling, one procedural misstep, or one financial stumble, and we could see marshals and asset seizures. This scenario raises a question Trump surely doesn't want to answer. If he's truly a billionaire, why couldn't he secure that bond? Genuine billionaires don't typically struggle to post $454 million bonds. They have liquid assets, diversified investments, and cash reserves. But most of Trump's wealth is tied up in real estate and other illiquid assets. When he needed $500 million in cash or bond coverage, approximately 30 companies rejected him. His lawyers even hinted at potential fire sales. That's not the financial profile of a true billionaire. It suggests someone asset-rich but cash-poor, or simply not as wealthy as he's claimed for years. The irony is striking. Trump was found liable for fraud because he inflated his asset values. Now this judgment is revealing that his actual financial situation is far weaker than he's portrayed. The fraud is being punished, and the punishment is exposing additional misrepresentation, specifically the pretense of being wealthier than he actually is. What does this all mean, and what's next? First, to be clear, there is no immediate seizure order right now. No court has instructed anyone to take over Trump Tower today, and there are no sheriffs at 40 Wall Street. The appeals court stay is still in effect, and Trump has posted the reduced bond. Enforcement is currently paused. Some headlines make it sound like asset seizure is imminent, but that's not accurate at this moment. However, the groundwork for seizure is absolutely in place. The judgment is final, and all enforcement tools are ready. If Trump loses on appeal or cannot maintain his bond, things could escalate very quickly. Trump's legal team has, quite frankly, admitted they're in a difficult position. This is where Trump appears increasingly desperate. His lawyers told the appeals court they couldn't obtain a bond, that 30 companies rejected them, and that he might experience irreparable harm, potentially leading to fire sales. These aren't my characterizations or political commentary. This is straight from Trump's own attorneys in court filings. When your lawyers use terms like fire sale and irreparable harm in pleadings, they're clearly not confident. It signals desperation. Additionally, Letitia James is prepared to act. She's been crystal clear about her intentions and readiness to proceed with asset seizure. She's identified specific properties and filed the judgment in multiple counties. This isn't bluffing. The legal groundwork is complete and enforcement mechanisms are in place. James also has political motivation. This case has elevated her national profile, and successfully collecting from Trump would cement her reputation. Once the appeals court protection expires, I wouldn't be surprised to see James move swiftly. Then there are the appeals. Trump is challenging the judgment itself, arguing the penalty is excessive and disputing the fraud findings. Could he prevail? It's possible. Appeals courts can reduce penalties or identify procedural errors. However, his odds aren't strong. The fraud findings were built on substantial evidence, numerous witnesses, and extensive documentation. Engoron's opinion was thorough and detailed, making it difficult to overturn on appeal. The most likely outcome, the judgment stands perhaps with minor adjustments to the penalty, and James proceeds with collection, making asset seizure a real possibility. Finally, there's the brand damage. Even if he avoids seizure, through a successful appeal or finding funds to pay, the fact that he was found liable for persistent fraud is now public record. That's difficult to overcome, especially combined with his inability to secure a bond from 30 companies. Having his buildings on an asset seizure list isn't the image a successful businessman wants to project. It's the image of someone caught in fraud. Here's someone supposedly a billionaire who cannot raise $500 million. A self-proclaimed dealmaker who couldn't negotiate with 30 surety companies. His lawyers are warning about fire sales. The reputational damage is permanent. The judgment is public record. All filings are documented. Even if Trump Tower is never actually seized, it's documented that it nearly was because he couldn't settle his debts. This situation isn't isolated. He's managing multiple legal battles, criminal cases, civil lawsuits, and more. Financial struggles in one case affect his ability to defend himself in others. Legal fees accumulate rapidly, and quality representation is expensive. If Trump is cash-strapped, struggling with bond payments and facing asset seizures, his options narrow. He may be forced to settle cases he'd rather fight, consider plea deals, or make concessions he'd normally refuse. He's experiencing both financial and legal pressure simultaneously. To summarize, Trump's properties are indeed on a seizure list. Judge Engoron found him liable for persistent fraud, with a judgment approaching $500 million. Attorney General James has made clear she's prepared to seize assets: Trump Tower, 40 Wall Street, 7 Springs, golf clubs, all potentially at risk. If he cannot pay, she's ready to act. The judgment is filed, properties are named, and her intentions are explicit. Trump's own lawyers have acknowledged they cannot secure a bond. 30 companies refused. They've expressed concerns about fire sales and irreparable harm. The appeals court granted temporary relief by reducing the bond and pausing enforcement. But the judgment remains. One lost appeal or missed financial obligation, and the state could begin seizing assets. The irony is profound. A man who built his entire persona on being a wealthy, successful real estate mogul, who emblazons his name on buildings, now faces the genuine possibility of those buildings being seized to settle a fraud judgment. The author of The Art of the Deal couldn't negotiate with 30 surety companies. The self-proclaimed billionaire has demonstrated limits when it comes to liquidity. After decades building a brand around success, wealth, and winning, that image is cracking. The buildings bearing his name in gold letters are now on a list, potentially becoming state property. We're not seeing immediate seizure or marshals today, but it's close. Just one unfavorable ruling away from reality. Trump knows it, his lawyers know it, and James knows it. The question isn't if, it's when. I'll be watching closely, and you should too. More to come.